Morning, everybody. After an extremely successful week at Underground, a week that was made even more successful by the rain, we're here first thing Monday morning to pick up where we left off on the city's efforts at affirmative action. The city is announcing that we have retained the joint venture of Brimmer and Marshall to do the necessary studies to evaluate the effects of racial discrimination in the past and the limited abilities of minorities and women to compete in the city's contracting and procurement business, to assess current practices in regard to whether minorities and women have an equal opportunity to compete as contractors and vendors, and 3, to propose alternative means to redress past discrimination for minority and female firms if such discrimination is established. I think in selecting the firm, the joint venture of Brimmer and Marshall, we've selected 2 of the finest economists in the nation. Dr. Andrew Brimmer was appointed by Lyndon Johnson to the Federal Reserve Board in 1966, and he served through 1974. Dr. Ray Marshall was Secretary of Labor under President Jimmy Carter, and the combination of their backgrounds we think give us the kind of expertise and the kind of credibility that we as a city will need as we attempt to answer the requirements of both the Georgia State Supreme Court and the United States Supreme Court. And this study will be conducted over the next 2.5 to 3 months, and we look forward to their guidance in helping us to run an effective minority business enterprise program, to enable us to continue an effective minority business enterprise program. I think that just looking at Underground, looking at the Dome, looking at Lakewood Amphitheater, looking at the zoo, looking at almost everything that we've done, the Science Museum, almost everything that we've done, it would have been extremely difficult for us to have done these kinds of things if we had not had a community in which every citizen felt that they had an equal opportunity and a fair chance in the economic activity of the city. And I think that Dr. Marshall and Dr. Brimmer, who is with us, will help us to both document and clarify all of the aspects of that program.
Mayor, I know that your study has to be done, but you don't have any doubt the city will construct a new program, do you?
Now, I think it would be difficult for this city to operate without a new program. There was a tremendous amount of talent and employment that went into Underground that has gone into almost every project that we've had. What we're talking about is the potential of that being negative rather than positive. And the city can't really afford that. The city has to see to it that we use all our talent in developing the growth and the lifestyle of our city.
In the Dome agreement, there's language about disadvantaged business enterprises replacing minority business enterprises. Is that the kind of form you could see replacing MBE as what are the substance of MBE without?
Well, I think that we're not trying to prejudge the study. The reason we asked Dr. Brimmer and Dr. Marshall to take a good look at this is that we want them to tell us. The Dome agreement was an emergency agreement to deal with a dome that had to be built. I mean, we had to get through that in a matter of a few months. And it was a kind of gentleman's agreement. We're now looking for something that will stand the legal tests that were put forward by the Supreme Court. of the state of Georgia and of the United States. And that would be a little more serious.
Dr. Bremer, what kind of a program would stand that dual test? What kind of numbers would be needed, used, etc., or wording for that matter?
First, we do not know. We're just getting underway with the study. The first time this kind of study has been done, as far as I can tell.
What about a model?
A model would look at the extent of participation in contracts in the past, relative shares, and above all, the evidence would have to turn on the extent to which the contracting process itself included means to incorporate women and minority groups as a part of the contracting industry itself. With respect to alternatives, and let us recall what the mayor said, we will pursue the study on the assumption that the record will show, and here I do not wish to prejudge it, but the record will show disparities. We've done enough work already to indicate that. One of the tasks we will confront is to test whether those disparities reflect discrimination. And that will be a research assignment, and we'll have to do the work to determine that. We will also look to see whether there are alternative ways of accomplishing the same objective, the objective being to broaden the opportunities to assure that blacks and women and members of other kinds of minority groups other than blacks have an opportunity to participate on an equal footing for the city's business as vendors. Now, among the kinds of things we will look at, and notice I'm saying we'll look at, we have not concluded that these ought to be the alternatives. We will look at outreach conferences, pre-contracting interviews, bonding arrangements, technical assistance for preparation of bids, time limits for participation, and so on. These are approaches which seem to be promising. They are not linked directly to racial differences, but we think it would be worthwhile to pursue them as a possible alternatives.
Dr. Bremer?
Yes?
Since the decision, the U.S. Supreme Court decision in the Richmond case, there have been other affirmative action cases, most recently in Birmingham, that suggest the court is willing to go the whole 9 yards to strike out an affirmative action. Given that, what prospect does any program have for withstanding the court's test at this point?
Well, first, this work we will do in Atlanta will focus on minority business enterprises and perhaps disadvantaged enterprises. The other 3 cases decided in 1989, at least, dealt with employment discrimination, turning on either Title VII or the Act of 1866. We will not pursue those kinds of questions at all in this study. And because I have not looked at the implications of the court's decisions with respect to employment, I wouldn't want to comment on it at this time.
Dr. Bremer, still going back to even the Bakke case and subsequent the word games that go on between what's a quota and what's a goal. Can you redefine that?
No, sir, I would not want to comment on those. Those are questions of law and interpretation, and we work in the area of economics, and I would want to defer to counsel for that.
Jim, if I could respond to your question, I think there has been a common tendency to view what the Supreme Court has said recently in 3, albeit somewhat related cases, in my view, very distinctively different cases. We think the Supreme Court is obviously composed of honorable, reputable men and lady who said that programs of this type are not per se unconstitutional, and they have, in the Croson decision, laid out the criteria by which a city could seek to reenact a program of that type, and that is our purpose in following that decision and seeing to it that we can meet those criteria. One of the mayor's earlier responses also, when he responded that of course the city would want a program of this type, I think you have to understand that the mayor is saying that the city of Atlanta believes that the factual predicate exists for the city to reenact a program of a similar type, and it is therefore the task of and hopefully the mission of the consultants to determine and detail those facts And should those facts not be in existence, of course, their other part of their study would be for them to guide us into alternative measures for hopefully achieving the same goals.
Ms. Brooks, what do you see as the criteria under which MBE can work in today's legal environment? What has been thrown out and what's still alive?
I think the Richmond case is a compendium of the court's thinking in the area of minority business enterprises. It's a very complex decision. It has to be analyzed. Every sentence almost contains some insight into the court's thinking in this area. It will be our task in working with our consultants to make sure that every view that the Supreme Court has announced in that case has been addressed, and hopefully in reenacting our program, if the factual predicate exists, we will take all of those things into account.
Well, you're saying that it's quite possible, too, when they're finished, that you will say, we were right all along and will continue with the MBE program.
No,
Possible.
I don't think so. It's very clear that our own program has been invalidated by the Supreme Court, and hopefully the result of this study that's being commissioned will be for the city to reenact a program of some type, either an MBE program somewhat similar to the one that existed, or an alternative program which is justified by the findings of this study. Yeah.
You know, what I say is, as neither economist nor lawyer, is that whatever we've been doing has been working for all of the citizens of Atlanta. And I compare Atlanta in 1971 with Sandra Day O'Connor's home of Phoenix in 1989. They still could not get a mass transit referendum passed. And one of the reasons was that they didn't include all of the citizens in the thinking about the system. And we were able to pass a mass transit referendum in 1971 in large measure because we were able to sit down and agree that as we built a mass transit system, all of the citizens of the city would participate in the total growth of the city, of the contracting, of the employment, and even that we even reduced the bus fare for 50 cents to 15 cents for 7 years because we wanted to be fair to the poor. And all we're saying is that we've been operating on what we felt to be both a moral and democratic principle. And that principle has been challenged legally. And we've got to find a way to reconcile what I feel we've been doing, which is morally right for all citizens, black and white, and the strict definitions that the court requires.
Secretary Marshall.
He's not here.
Is that, oh, I thought this was the gentleman.
That's
I knew that's Arthur
Councilman
Bremer.
Leah.
I'm sorry.
Voted today. Or demoted.
Dr. Bremer. All right, then I'll hand it to you. Is your idea to put together a study here that can be translated, put to use all over the country? Is Atlanta to be the model in your opinion?
No, this study is specific to Atlanta. I believe one of the criteria specified by the court is that the foundations and statistical base be specific to the jurisdiction. And so while the analytical approach methodology might be transferable, the specific content will be confined to Atlanta.
I can ask just two detailed questions. First, how much is this study going to cost? And while it's being done, what will happen to the functioning of Atlanta's minority business program?
Mr. Walker. It's our purchasing director.
There's a proposed amount of $517,000 for the cost of the study. What will be occurring in the minority business enterprise area while the study is being done may better be answered by Rodney Strong, who's our contract compliance officer. But as the mayor told you several months ago, when he had a press conference in the atrium of this building, is that the business of the city goes on. Rehabilitation or reinstitution in the event that such is supported of our MBE program is a priority of this administration, in my judgment. But the business of the city has continued.
Have any contracts gone out to significant contracts, let me put it that way. Have any gone out to bidders that have not included minority participation in the interim since the court struck down the program?
We have had agreements, and no specific agreements come to mind right now, but we have had agreements since the court struck down the program that have not had minority participation in the amounts that were present in contracts before the contract was stricken.
What does that mean? He said contract, you said agreements. Are we playing, we're talking the same thing?
Oh, no, we're not playing with words. Contracts and agreements are the same thing. Yes.
Since the court struck it down?
Since the court struck it down, yes.
The offers or bids have been made below the 35% or whatever?
We have received bids since the court decision that have included, have not included any minority participation, yes. We have received.
A change from?
That is, yes, that is somewhat of a change that, as things were prior to the time of the decision.
Any idea what the dollar amount of those has been? Or?
Totally no. We have had agreements that have been in the $1 million range. We have had agreements that have been higher than that. We have had agreements that have been lower than that, yes.
Of course, remember, this is a lame duck administration winding down. We've done just about everything we set out to do. I can say that, but nobody else can.
Jim, just to address the second part of your question, the Office of Contract Compliance is still moving forward, as we always have. We have a number of contracts that were in existence prior to the Supreme Court decision, so we're still administering those programs. We're still monitoring those programs. We're still working with pre-bid conferences and doing many of the things that we did before the program, except now, of course, we cannot require minority business participation. There are a number of projects like Underground Atlanta that we're still heavily involved in terms of ensuring the minority participation be in place because, of course, we had those agreements long before the Supreme Court ruled. And, of course, we're also working on certain things like the Georgia Dome and those things as well.
Well, thank you very much. And I want to particularly thank Dr. Brimmer for being willing to take on this task force. He and Ray Marshall, I couldn't think of a better team anywhere in the world.
Thank you.
I'm going to read your report.